Well, the great Pentagon Papers case, ominously named United States of America versus the New York Times. The Attorney General, John Mitchell, Nixon's Attorney General, sent this telegram to the New York Times requiring them, demanding that they cease and desist from publishing any of the contents of the classified Pentagon study of our involvement in Vietnam, and demanding the return of the Pentagon Papers to the Department of Defense. The telegram, I forgot to mention the other day, was misdirected. The FBI didn't have the correct telex address for the New York Times, and the telegram actually was sent to a fish company in Brooklyn. And that was retransmitted to the Times, so they got the message, and they rejected it and decided to go ahead and publish. And the next day, on the 14th of June, 1971, the government filed suit in the Southern District of New York, federal court for the Southern District of New York, that's in Manhattan, seeking an injunction prohibiting the Times from publishing the Pentagon Papers, seeking emergency relief, a temporary restraining order, and then a preliminary injunction that would stop publication while the lawsuit was pending. And in New York, in a busy federal district like that, in New York, as is true in most multi-judge districts, when you go into the clerk's office to file your lawsuit, you hand the papers to the clerk and you pay the filing fee, the judge is assigned to the case by random. And in New York at the time, there were probably 15 or so, maybe as many as 20 federal district judges in New York. And back then, when you went and filed your papers, the clerk would turn around and they had a container that looked like a bingo machine, and it had little cubes with the initials of the judges on the cubes. And the clerk would spin the thing and pluck out a name, pluck out a cube, and that would be the judge who was assigned to the case. Now it's all done by computer, but this was 1971. And when the government went in and filed their suit against the New York Times, the clerk reached into the machine and pulled out the initials of M.G. Murray Gurfein, a federal district judge who had just been appointed by President Nixon, and it was his first day on the job. The Pentagon Papers case lands in his lap. He rose to the occasion. He granted the government a temporary restraining order on that Tuesday, set the case, that stopped the Times from publishing, set the case for hearing on the preliminary injunction motion for that Thursday, and the case would proceed in that way. As soon as the government got the TRO, the temporary restraining order, stopping publication, Daniel Ellsberg, who had leaked the Pentagon Papers to the New York Times, got busy again. Ellsberg, very interesting character, you may know something about him. He's around, lives in the Bay Area. He had served in Vietnam as an officer. He was a brilliant young man, scholarly for a soldier, and he had participated in the Pentagon Papers study. After his experience in Vietnam, he got disenchanted with the war effort and became a bitter opponent of the war. He was employed in 1971 at the Rand Corporation in Santa Monica, and they had a full set of the Pentagon Papers case, study there. And so Ellsberg, when he went down to the basement of the Rand Corporation, when he couldn't get anybody in Congress to pay any attention to the existence of the Pentagon Papers and what they revealed about how duplicitous, dishonest officials of our government had been in getting us into the Vietnam struggle, he undertook to get the papers copied. He went down to the basement of the Rand Corporation with a Confederate, and they ran a Xerox machine, and they copied the 47 volumes of the Pentagon Papers. And it was that set that Ellsberg leaked to Neil Sheehan, the main New York Times reporter who was covering the war in Vietnam. The Times had the papers for weeks, maybe months, and they were able to devote expert attention to them, make sure it wasn't a hoax, make sure that there wasn't, in their view, material in there that would result in really serious harm to the national security, to write the papers, to write the stories about the papers and so on, and then to go ahead and begin publishing. But then all of a sudden, they're stopped by court order. Well, Ellsberg didn't take that lightly. He got in touch with the Washington Post and with Ben Bagdikian, who was then national editor for the Washington Post. As you may know, after he left the Post, he came to Berkeley and was for many years dean of the Graduate School of Journalism here. Gave me my first job here. Ellsberg got in touch with Bagdikian and arranged for a clandestine meeting at a sort of a sleazy motel in Cambridge, Massachusetts, where Ellsberg was hiding out at the time. He was hiding out because he was well aware that the FBI was suspicious of him. And after the Times had started publishing, he knew that he would ultimately be exposed as the leaker, and so he was laying low. So Ben Bagdikian went up to Cambridge, and Ellsberg had laid out the Pentagon Papers on one of the beds in the motel, and Ben sat there and looked at them, and they looked like they were authentic and so on. And yes, indeed, the Post was well aware of what the New York Times had done, and yes, indeed, they would be interested in publishing as well. So they loaded up the Pentagon Papers in grocery sacks, and Bagdikian took the shuttle on the airplane from Cambridge back to Washington, accompanied by the Pentagon Papers. He bought a seat for the Pentagon Papers next to him. He wasn't about to check them as baggage. And the Post then got busy on a story. They brought in their Vietnam experts and so on, went over the papers, and decided to start publishing their series, whereupon the government immediately sued the Washington Post in the district court for the District of Columbia, where the judge was Gerhard Gesell, a very experienced federal judge. Yes, Nicole? Can't hear you.
Why were the Pentagon Papers not confiscated?
Why weren't they what?
Why weren't they confiscated by the government?
Well, they were secure. I mean, the government has zillions of documents spread all over the world. And there were multiple copies, apparently, of the Pentagon Papers. Undoubtedly, there was a set in the Pentagon. There was one at the Rand Corporation, which they had some involvement in the creation of the study. Do you have a question? No? Okay. So the Washington Post gets sued as well, and the case went up. Judge Gerfine in New York, having heard the argument and received the evidence put on by the government for why the Times should be stopped from publishing, Gerfine refused to give the government the court order that it sought. And the government immediately appealed. The Court of Appeals for the Second Circuit is in the same federal building in Foley Square in New York. And the government took the elevator upstairs to the Court of Appeals and filed their appeal immediately. And the Court of Appeals granted a stay of Judge Gerfine's decision so that the government continued to be, that the Times continued to be prevented from publishing. In Washington, it was the other way around, and the Court of Appeals reversed the order preventing the Post from publishing. Anyway, they both, with lightning speed, went through the Court of Appeals. The Pentagon Papers litigation, from beginning to end, from filing in the trial court to decision by the United States Supreme Court, was about 15 days. It was the all-time speed record for a case proceeding from filing to disposition by the United States Supreme Court. It held the record until Bush versus Gore in 2000, when the Supreme Court intervened in the presidential election in Florida and delivered the presidency to George W. Bush. That's now the world record holder for speed through the Supreme Court. But when the case reached the Supreme Court, there was no time. Everybody viewed it as a major emergency. All the parties certainly did. All the judges involved viewed it as an extreme emergency. This had to be decided ASAP. Therefore, the normal briefing schedule was condensed, and the parties were required to exchange briefs virtually overnight. The case was set, here we are in June. Normally, the court is just about done with its term, having decided all the cases that term, and just finishing up its business. And the court all of a sudden set oral argument on the Pentagon Papers case for a Saturday, unheard of. And they set 2 hours for the argument, twice as much as they normally give a case. And the lawyers would not get the briefs from the other side to see what their arguments were until about half an hour before the argument. Wouldn't even have time to read them before they had to get up and argue the case in the Supreme Court. The justices didn't have very much time. The government, consistent with its position throughout that publication of the Pentagon Papers would seriously impair our national security, made a motion in the Supreme Court to have the argument held in secret, what's called in camera, behind closed doors. Public not permitted, press not permitted to see. That motion was denied by a vote of 6-3, a little close, so that we were able to see what the argument looked like and sounded like. The court in 1971 was obviously very different from the court that we know and love so well now. 9 old men, basically, 9 old white men. And the Chief Justice at the time was Warren Burger, who was a Nixon appointee, had been appointed to be Chief Justice by the President, whose action was being challenged here. A very conservative man and very suspicious of the press, never trusted the press or its motives. And then Justice John Marshall Harlan, fairly well along in years, was a Republican, a very procedurally conservative man, and a man of great principle, and a scholar, and very thoughtful, but deeply conservative in many ways. Next to him is Hugo Black, who had been on the court since Roosevelt, had been a senator from Alabama, and he was one of the 2, along with William Douglas, First Amendment absolutists on the court. They took the First Amendment literally. Congress shall make no law abridging the freedom of speech or the press. And they would predictably be highly upset that the government was trying to shut down the New York Times from publishing. Way over on the right is William Brennan, who was an Eisenhower appointee, who was one of those ideological drifters that some of you wrote about in your paper, who started out as a Republican, became more liberal over the years, was a First Amendment lion. He wrote the New York Times versus Sullivan, which we'll look at soon. And he would be suspicious of the government's motives and showing required to obtain a prior restraint in this case. In the back row is Thurgood Marshall, the greatest civil rights lawyer of all time. He had served as solicitor. He served on the Second Circuit. He served as Solicitor General of the United States, representing the government in the Supreme Court. And then he was appointed by President Lyndon Johnson to the court. He always would be suspicious of the government's reasons for infringing on individual liberties of any kind. Way over in the right side was Harry Blackmun, who in 1971 was brand new to the court, had just been appointed by Nixon. He, along with Chief Justice Burger, both came from Minnesota, from the Twin Cities. They had known each other since being children together. They'd gone to school together as kids. And Burger got to the court first and had the bigger name and so on, and then Blackmun gets appointed. And everybody thought, well, that's just like giving Burger 2 votes, because Blackmun will do whatever Burger tells him to do and follow him around like a little puppy dog. Well, you know what happened with Blackmun. Not in this case, but over his tenure at the court, he moved ever leftward to the point that when he retired, he was considered a liberal on the court. He was, of course, the author of Roe versus Wade. And I think the experience of having written that decision and received tons of hate mail, criticism from all quarters practically, about that landmark decision, that animated him to move off where he had been and move leftward, under the tutelage, I think, of William Brennan, who befriended him as he befriended everybody in the court, but sort of took Blackmun under his wing. Next to Blackmun is Byron White. We've talked about him before. He was a Kennedy appointee, nominally a Democrat, no friend of the press. Don't know what he would do. He's normally a swing vote on the court in 1971. And then finally, Justice Potter Stewart, the man in the middle, the swing vote, on many, many cases. He was appointed by President Eisenhower in the 50s. He was a Republican from Cincinnati. He was a middle-of-the-road guy in every respect. Interested in press, thoughtful about the press and its role, and so on, and somewhat supportive. Very active in questioning from the bench, as you'll hear during the argument. So there's the list. Ranked in my idiosyncratic way by their openness to the First Amendment, to doing the right thing in First Amendment cases, with Berger on the far right, followed by Blackmun, Harlan, White, Stewart right in the middle, Marshall, Brennan, and then the two absolutists. The case was argued in the Supreme Court by the then Solicitor General of the United States, Erwin Griswold, and here he is in his cutaway, his tails, striped pants. That's what the Solicitor General, at least a male Solicitor General, wears traditionally in the United States Supreme Court. Griswold had great credibility with the court. He had been a long-time dean of the Harvard Law School, was a nationally recognized scholar. As Solicitor General, he had appeared before the court many, many times. His word was good with the court. He was not going to pull any punches. He was not going to deceive the court in any way. He was not going to try to win the case no matter what. He had great credibility with the court. But he, after all, represented the government as is his client. And representing the Times, as I said, the regular law firm quit when they decided to publish the Times, and they hired Professor Alexander Bickel from Yale Law School, a renowned constitutional scholar, to represent the Times at the argument. When the case was before Judge Gerfein in the district court, at one point in the hearing on the injunction, Gerfein asked Bickel, what good would it do in 1971 for the public to read what the American ambassador to the Soviet Union thought in 1968? And Bickel's astonishing response to that was, this is one of the great all-time answers to a question from a judge during the argument. He said, I think, Your Honor, the First Amendment forecloses you from asking that question. That's a provocative answer. I've thought about using that a couple of times in an argument I never dared to. But what Bickel then did, having got the judge's attention with that answer, was educate the judge that the First Amendment confides decision about what and when to publish to the press, not to the judiciary, which is an important point. Judges are not in the business of being super editors, supervising the press. Anyway, Bickel shows up to argue the case. The argument, as I say, took 2 hours, but I have crudely edited it down to about 20 minutes, featuring some of the highlights. And I'm not sure this technology will work, but let's see if we can hear the argument. Griswold starts.
It is important, I think, to get this case in perspective. The case, of course, raises important and difficult problems about the constitutional right of free speech and of the free press. And we've heard much about that from the press in the last 2 weeks. But it also raises important questions of the equally fundamental and important right of the government to function. Great emphasis has been put on the First Amendment, and rightly so. But there is also involved here a fundamental question of separation of powers in the sense of the power and authority which the Constitution allocates to the President as Chief Executive and as Commander-in-Chief of the Army and Navy. And involved in that, there is also the question of the integrity of the institution of the Presidency. Whether that institution, one of the three great powers under the separation of powers, can function effectively. The problem lies on a wide spectrum, and like all questions of constitutional law, involves the resolution of competing principles. If we start out with the assumption that never under any circumstances can the press be subjected to prior restraint, never under any circumstances can the press be enjoined from publication, of course we come out with the conclusion that there can be no injunction here. But I suggest, not as necessarily conclusive in this case, but I suggest that there is no such constitutional rule, and never has been such a constitutional rule.
Understand, however, that your brother counsel on the other side really questioned any of this. I thought that at least for purposes of this case, they conceded that an injunction would be not violating of the First Amendment, or put it this way, that despite the First Amendment, an injunction would be permissible in this case if the disclosure of this material would, in fact, pose a grave and immediate danger to the security of the United States. That is, that for purposes of this case, they've conceded that, but they have said that, in fact, the disclosure of this material would not pose any such grave and immediate danger.
Mr. Justice, if they have conceded it, I am glad to proceed on that basis.
No, I'm not conceding it for them, but that has been my understanding of what the issue is. They'll make it clear.
I may say that their briefs were served on me within the last 15 minutes, which are, or last hour, which was entirely in accordance with this court's order, but I have not seen their briefs. I do not know what is in their briefs.
In other words, I had thought in my analysis, and I haven't had the benefit of much more time than you have, that this basically came down to a fact case, that the issues here are factual issues.
And that, Mr. Justice, is extremely difficult to discuss
Here in this
in
open
open court.
I understand it, Mr. Solicitor General, and you tell me, please, if I misunderstand it. Your case doesn't really depend upon